Yes, ground 3.
Yes, my lord. Ground 3 is a collection of several related but distinct points or errors which EasyGroup says the judge made in his global assessment of the likelihood of confusion.
Yeah.
Our overall case on this ground is that the judge applied the established principles such that he made no error of law or principle, and that his decision that there was no likelihood of confusion was eminently open to him on the evidence and shouldn't have been interfered with. But dealing with the separate points, the first and the one which my learned friend took the most time on was on the evidence of alleged confusion.
Yeah.
And I just want to take your lordships to the actual grounds of appeal, because I was a little bit surprised by the way in which that point was developed. We can take the core bundle tab 2, please, page 17. So this is ground 3 from paragraph 5 onwards, and it's paragraph 6 that concerns this aspect of ground 3. And it's put in this way: the judge erred in law by finding that the instances of actual confusion were administrative errors. The instances of actual confusion identified by the judge, you see there's a paragraph reference there, that's to paragraph 119 of the judgment, in which the judge addresses 7 specific instances of alleged confusion.
Yes.
They were the ones that were most promising in the judge's view. Those were not any of the misspelling examples that your lordships were taken to this morning.
Hold on, you skipped over the first sentence. Sorry, you read it, but you skipped over the paragraph references.
Yes, my lord.
So, as I understand it, although it's expressed as one point, there's actually 2 points being made here. The first sentence is saying he was wrong, 112 to 113, to say these are administrative errors. And the second point is that even when you get to 119, that's probative of the existence of likelihood of confusion. So there's 2 points.
Well, I didn't read it in that way. Paragraphs 112 and 113 of the judgment are on page 110 of the court.
That's TVIS.
Tab 11. Yes, that is in which those paragraphs appear in the section in which the judge deals with the principles. So those paragraphs are not ones where he's looking at the misspellings. That's paragraph 117.
But the administrative point comes up in 117, doesn't it?
Well, possibly, but I certainly did not read it that way. I read it, I mean, it's one point, it's one paragraph in a ground of appeal that is itself divided up into 5 points. So I didn't read it as containing itself 2 further separate sub-points. And that was borne out by the respondent's skeleton, which was their permission skeleton, which relied on for the purposes of the appeal. So you get a tab 6 of the core bundle, page 37. And so the point is developed in paragraphs 23 on page 37 to 26 on page 38.
So the short point is you say the skeleton identifies 119.
Yes.
And 112 and 113 on the point about administrative error and TVIS. So the short point is you say that the points in 116, is it 116 and 117?
117
and 118.
117 and 118
Yeah.
are where the judge addresses the misspelling examples. And we interpreted at least the ground of appeal, or this part of ground 3, to be just targeting the judge's finding in paragraph 119.
Yeah.
Be that as it may, we've been taken to the other misspellings and points have been taken on that today, so it falls to me to respond to them. But in relation to the alleged error of law, we say the short point in response to that is that the judge doesn't actually use the expression administrative error in relation to any specific instance. Even if he had done, that was open to him as a matter of law. And under the guidance in the TVIS case of this court. So in that is in Appeals Authorities Bundle 5, tab 39, page 1478. Sorry, it's 1479. No, sorry,
it's bridging the pages, so it starts at the bottom of 1478.
Thank you, Arnold, yes. So, my Lord Justice Arnold in this case saying, I do not have any difficulty, second sentence, do not have any difficulty with the proposition that an instance of alleged confusion may turn out upon examination to involve some administrative error or other mistake which does not demonstrate any relevant confusion on the part of the person in question. So to the extent that that is what the judge is finding as a matter of fact.
Well, to be sure, I get that point, but as I was exploring with Mr. Edinburgh, as I understand it, what he relies upon the evidence for, and it's both categories of evidence, but he may be on more firmer ground with the second category. But he relies on both categories of evidence. Firstly, as shown there's actual confusion, to which your response on this part of the case is to say, no, it ain't, because that's what the judge found, it wasn't actual confusion. But then the second way he relies upon it is to say, well, this is evidence of the propensity to confuse the mark and the sign.
Yes. To which the principal response is, well, if there was a propensity, then it would have actually happened. And the judge has said as much in paragraphs 120 onwards. And he said, certainly in relation to the 7 in paragraph 119, he said, well, even if I'm wrong about those 7, and they do show confusion in the relevant sense, then I would expect to see more, given the long period of side-by-side trading and the efforts that were made to find evidence of confusion.
Yeah, so you say this is a W3 case.
Precisely, my lord, yes. Even if he's wrong about, in his assessment of the instances. My lord, there is one housekeeping point at this stage. There are pages that aren't in the bundle. They're missing pages from 3 of the instances of actual confusion. Now, my learned friend didn't take you to any of those with missing pages, but on the assumption that your lordships might, he did cite some of them, so he referred to
in
them.
which case we ought to have the missing pages, sure.
Okay, great. So what we have here comes to
documentation for the ones wrong.
Are they missing from the electronic file as well?
yes. We did raise it before. We did raise it after the bundles had been, and so
there's a new index to the supplementary bundle.
there's
1, 2, 3 inserts.
there's 3 inserts. Yes, in the normal way, 89A follows 89.
Yeah.
That's helpful, thank you.
So in relation to the specific instances, there are three categories that the judge deals with. First, in paragraph 117, are instances of the defendant's customers mistakenly referring to the defendant as Easylive or Easylive auction.
Yeah.
The second category in 118, 4 examples where customers of Easylive wrongly referred to Easylive as Easylive. And the third are the 7 which the judge, in relation to which the judge said, seemed to me to raise a possible suggestion of confusion. And our overall case in response to that is that we endorse everything that the judge says about them. And we emphasise what the judge emphasised, is that one needs to be cautious when there is only documentary evidence and you're not hearing from any of the witnesses who are the authors of these documents. As far as the...
Well, that's a proposition which is supported by authority, but also supported by authority is the fact that the problem with the live witness evidence is that people are trying to reconstruct years after the event what their thought processes were at the time, in circumstances where the real question is not what their thought process was, but what their unconscious assumption was. So,
yes,
in some senses, one is between a rock and a hard place, evidentially, because yes, you've got to be cautious with documentary evidence, but at least documentary evidence is objective. You make of it what you can.
yes.
Live evidence can be more helpful, but it's subject to fallibilities I've just identified.
Yes, but it certainly has been useful in other cases. The Easylive case being the prime example, and that is relevant because the case between EasyGroup and Easylive, because there were, as in this case, a number of instances of what were held to be misspellings, and the EasyGroup in that case, as they do in this case, says, well, no, these actually do show actual confusion. And it was the defendant in that case who actually served evidence from consumers to say they weren't confused, so they hadn't associated Easylive with EasyGroup. And so yes, my lord, I take your point that it's not always helpful, but in some cases it has been helpful, and one is left doing one's best with the documents, and it's difficult to reach definitive conclusions. And it's also, in my submission, means that this court should be more cautious in undermining the judge's conclusions. So in relation to the misspellings, in my submission, the judge was certainly right to conclude that whatever they show, they do not show confusion in the relevant sense. My learned friend maintains that they do, but in my submission, there wasn't really any cogent basis for concluding that on the basis of the documents. But in relation to the secondary point, they may show the ease with which customers are confused. That is, in my submission, that is not a conclusion that can be reached if it is plausible that each case is an instance of a typo.
Why?
An error.
I don't understand that. I mean, on the specific facts, you might be right. But why is a general proposition? Because I mean, the whole point about likelihood of confusion is it's all about what the academics call consumer search costs. So we're trying to avoid consumers not having their search for the right goods or services impeded. Now, if you can transpose letters very easily on a keyboard, type one word when you mean another, why is that not a relevant potential source of?
Because if you know that you're looking for Easylive and you typed Easylive, then you will, when you get a result, realise that you've made a mistake.
Why? Because you haven't noticed it. Suppose you're looking for Easylive.
Yes.
You type mistakenly Easylive.
Yes.
You don't notice that you've typed the wrong letter. So why do you notice it? You've got the wrong result.
Well, because you see Easylive as opposed to what you intended to search for, which was Easylive. So, I mean, I understood, my lord, to in nuclei to be making a similar point. So perhaps I can turn that up. So that is.
The example we just looked at, TVIS, was exactly the case at that point. When some of the evidence was of actual confusion, but one of the examples that was looked at was accepted to be a typographical error, P rather than V. But the point was made, well, you know, it's an easy mistake to make. And it was in itself a fairly small piece of evidence, but it was evidence of the risk of confusion.
I mean, it shows that there is a risk of making a mistake, but in my submission, I'll come back to it, that if it's a genuine typo in the sense that you mean to type one thing, so you know what it is that you want to type, you've just typed you pressed the wrong button on your keyboard, then that is not probative.
Okay, where in nuclei did you want to look at?
Yes, sorry, so it was Authorities Bundle 3, tab 28. Paragraph 57.
Paragraph
57 on page 971.
Thank you.
It's actually in the context of identity of mark and sign that this paragraph appears. But you see it about half the way down. I also accept the point made by counsel for EasyGroup that even exercising a moderately high level of attention, consumers may mistakenly write or say easy offices when they mean to write or say easy office, and vice versa. Again, that is not enough.
Yes, but as you rightly acknowledge, that's considering identity. It's not considering the idea of confusion.
It is considering identity, but that's not something that that then was carried through into considered to be a factor in favour of confusion. If you type something by mistake but misremembering, then that's different. But if it's making an actual mistake in the typing rather than remembering, then in my submission that's not probative. It's certainly not probative. Certainly all it does, it shows a in principle propensity. But if there is then no actual evidence that that propensity is followed through, and people are actually making a genuine mistake of confusing them, then the weight of that evidence disappears in my submission completely.
Is your point based on the fact that when you type Easylive into a computer, you get something which is demonstrably very different from what you would get if you typed Easylife? In other words, you find yourself with an auction site as opposed to Easylife's website. Is that your point? So there's no, the mistake doesn't carry through in a relevant sense because you're not going to be confused as the two services.
But that's a respondent's notice point.
I see.
So I do make that point, but that is contrary to what the judge has found, which is that he has found that the services are actually identical in the sense that when you compare the defendant services with the services in the specification rather than what Easylive actually does.
Yeah.
But yes, I that is part of our case, but on the respondent's notice. So my learned friend has conceded this morning that every single one of the misspelling examples could be an instance of a typo being made. And V and F are next to each other on the keyboard. And that is what the judge has found as well in 117. So we say, for that reason, they do not assist EasyGroup's case. And then in relation to the 7 in paragraph 119, which my learned friend didn't spend any significant time on, he said the judge has looked at them, he's come to a rational conclusion about what they show, and he's held that they are not confusion in the relevant sense. But even if they are, they're not significant, which is the W3 point. And that is because he would have expected to find more than 7 examples, given the very extensive disclosure searches, so that the figures are 44,000 or so records from Easylive auction and 1.4 million from Easylive, and the long period of side-by-side use. My learned friend makes a point on the scale of the Easylive auction business throughout the period, but he seems now to concede that it was at least significant on Easylive auction's side from 2017. And that is supported by the fact that one of the instances of confusion that they rely on dates from 2017. In fact, 2 tabs 14, 15 of the supplementary bundle. So the business must have been sufficiently significant by 2017, even on EasyGroup's own case. So we've got 2017 until whenever disclosure took place, which I think was end of 2023. So 6 years. You compare that with Nuclei, where the period of side-by-siding trading was over 5 years, and there it was held to be significant that there was no evidence of confusion. So the judge had reached the conclusion that there was no likelihood of confusion before considering the evidence. He went on to consider that evidence in the way that he is meant to do, and decided that it did not shake him from that conclusion. The weight to be given to this factor is a matter for the judge. He didn't make any error of law or principle, and again, as we say, there's no basis for justifying interference with his conclusion. So that's the first point under ground 3. The second point is imperfect recollection. EasyGroup says the judge should have, but failed to consider the possibility of imperfect recollection. We say the judge clearly did have in mind imperfect recollection, because he cites the relevant principle of paragraph 81B on page 104. Principles with which the judge was, of course, well familiar. His findings in relation to the common use of easy and Easylive were, in my submission, sufficient to discount the possibility of the average consumer mistaking the respondent signs for Easylive, even taking into account imperfect recollection. And as I said, in relation to the examples of misspelling, if they are typos, they are not instances of imperfect recollection. The third point is that the EasyGroup argues that the findings as to the significance of the similarities between the word mark and the defendant signs were inconsistent with the findings as to distinctive character of the stylized mark and the signs. So, picking up the judgment, paragraph 137. So this is the comparison of the word mark with the defendant sign. He says the average consumer will see the similarity as arising from use of the word easy My submission, there's nothing wrong with that. And the distinctive character of the stylised mark he deals with in paragraph 83. And he says it lies in summary in the combination of two words, easy and life, to allude to the Easylive concept reinforced by the triangular device. And in 84, in the case of the defendant's signs, the dominant element is the combination of words used to make up those signs. There's nothing wrong with his conclusions there. My submission, this is all perfectly consistent. And crucially, the words life and live, auction, etc. are different. And in each case, they are pushed together to make different made-up words. So again, no basis to interfere with the judge's decision. The fourth point, at least in my learned friend Skeleton, was that EasyGroup says there's a material gap in the reasoning of the judge from holding that while the likelihood, I quote, the likelihood of confusion is very low, there did not exist a likelihood of confusion. And they focus on paragraph 121 of the judgment. And the last sentence of that paragraph, so page 113, where the judge says, the fact that there are only 7 examples of confusion suggests that the likelihood of confusion is very low. But EasyGroup misses out the last bit, indeed insignificant. So in my submission, this is a pedantic point about forms of expression. It's obvious that the judge had the statutory test in mind and was applying it. And finally, under ground 3, EasyGroup says that the judge did not have regard to the interdependency principle, which is the interplay between identity and similarity of services and identity and similarity of marks, mark and sign. The judge cited the principle of paragraph 81G on page 104. And then, of course, he expressly took into account, when finding that there was no likelihood of confusion, that the services were identical against the respondents in paragraphs 105, 106, 135 and 136. That was what he was required to do. He wasn't required to do anything more. And then finally, on ground 4, there are no separate arguments. It's common ground that the decision on validity will follow that on infringement, at least in relation to the Easylive auction signs, given that the mark is Easylive auction. So we say, for all those reasons, the appeal should be dismissed. There's no error of law or principle. The judge's decision that there was no likelihood of confusion was not plainly wrong. There's no other identifiable flaw in the judge's treatment of the question to be decided. He came to the right decision. Even if your lordships have some doubt about that, that's not enough, because his decision was eminently open to him on the evidence. So next, turn to the respondents' notice points. There are 2. The first concerns the comparison of services, as I indicated to my Lord Justice Zacaroli. And as we've said in our skeleton, if the court allows the appeal such that it is necessary to carry out a fresh assessment of whether there's a likelihood of confusion, the respondents challenge the findings of the judge that all of the respondent services, so each of those three categories of service that we looked at earlier, are identical to at least some of those in the specifications for the Easylive marks. And in this context, I want to start by focusing on the judge's findings in relation to the word mark, so the later mark just for the word Easylive, and take you to the judge's findings in relation to that mark in paragraph 135, page 114. So here he says it's common ground that the defendant's advertising service is identical or at least highly similar to the advertising and marketing services for which the Easylive word mark is registered. Still common ground. And then he goes on further, for the reasons set out when dealing with the Easylive stylized mark, see paragraphs 95 to 101 above, it seems to me that the defendant's catalogue service and the defendant's auction broadcast service are identical or at least highly similar to the claimant's registration for retail services, including online retailing and retailing through the medium of broadcast in respect of a wide range of goods. I took you to the specification for that later mark in my summary at the beginning, and what we dispute is the judge's findings that that spec, encompassed within that spec, are the auction broadcast service provided by the defendants. So again, that's the service which provides an online platform for auction houses to broadcast their auction sales to customers and for customers to bid for lots for sale in those auctions in real time. So we say that's not encompassed by retail services. And we also say that it's made the same point in relation to the catalogue service, which is the service which allows auction houses to upload their auction catalogues and auction event details on the defendant's website where they can be viewed by customers. And the way that I characterise...
Can I just ask you a quick question? I don't... You just characterised your position as being not identical, but of course what the judge has said is identical or at least highly similar. Do you say he's wrong to say highly similar as well?
We say if there is similarity, then it's at a high level of generality. So the way that...
And where... So no doubt you'll be developing this in a moment, but identity is a hard-edged test, whereas similarity is an evaluation.
Yes.
So you're going to have to show us an error of principle on that evaluation.
In relation to the highly similar.
Yes.
Yes. Okay. But my principal point and the principal point raised by the respondent's notice is the judge's. It challenges the judge's finding in relation to identity.
But that's why I'm asking the question.
Yes.
Because how does it help you if he's wrong on identity, but you can't challenge the finding that they're highly similar? It doesn't make any difference.
Well, for this reason, my lord, because as I said when introducing these respondents' notice points, we only get here if the appeal has been allowed and your lordships are conducting a fresh assessment. So if on that, so then when conducting that fresh assessment, your lordships have to say, well, on what basis are we proceeding in terms of the comparison of services?
Absolutely, you're absolutely right about that. And so I maybe misphrased my question, but why, if we are reconsidering likelihood of confusion, why does a change from identical to highly similar lead to a different outcome?
Well, the identity is obviously closer than highly similar, and
Yes, of course. I mean, it's not the same thing, but it's rare that it's going to make a material difference. I mean, look at Skykick, for example. It didn't make a difference.
Well, it's,
I mean, of course, you know, it's dangerous referring to facts of different cases, but I'm struggling to think of any case where the difference between identity on the one hand and high similarity on the other hand of the relevant goods or services was critical to the outcome.
well, it feeds into my Lord of Justice Zacaroli's question earlier, and what would happen when you typed in something mistakenly and you get something that you're not expecting to get. If that something is a different operation, so a non-identical operation, and then that is going to affect your assumption as to whether it's the same people or connected.
Right. So you say it does make a difference.
Yes, but the difference between identity and similarity does make a difference. Yes.
Fine. Well, that's clear. I understand. And thank you for the explanation. But what about, are you challenging highly similar as well? And if so, on what basis? You carefully explained to us that your submission is that the difference between identity and high similarity could be helpful, taken together with other factors which you rely upon, and I've got that. But do you challenge high similarity? And if so, how?
Well, I mean, high similarity is a label. I would accept that they're similar in the sense that the services relate to the sale of goods. They are connected to the sale of goods. If that means high similarity.
But I mean, the evaluation of the degree of similarity is classically a matter for the first instance tribunal.
Yes. Yes, no, I accept that. But if he's wrong about identity, then he's got the comparison wrong.
The hypothesis here is that this court is reconsidering likelihood of confusion.
Yes. So if I'm right and the judge has got the comparison of services wrong, in the sense that they are not identical, because the difficulty is that the judge has said, well, they're identical or highly similar. It's on the basis that of his interpretation of what retail services are and the bringing together services are. If he's wrong about that, and with the consequence that they're not identical, then that undermines this whole comparison. So the way I would put it is that if I'm right and they're not identical, then this court needs to look again. It needs to compare the services again. And I don't go as far on this appeal as to say that they're not similar, such that the threshold test is not met. But the similarity is not such as to lead to a likelihood of confusion. Because the average consumer would recognise that the type of offering is different. And that, combined with both the differences in the signs and the common use of both Easy and Easylive, is sufficient to avoid a likelihood of confusion. So on this issue of interpretation, so that's how I would characterise the error of the judge, is that he has wrongly interpreted retail services, which is a black and white question, and one that can be revisited on appeal. And we say that retail services is not a clear or precise term, and in accordance with the guidance in Skykick, follows it must be confined to the substance or core of the possible meanings. And we say that there are two aspects of that core of retail services. The first is that the provider of the services sells goods to its customers. And the second is that it doesn't involve an auction.
Why does a retail service necessarily imply a sale? I mean, if we go back to the formulation that we had before retail services bringing together, I mean, the service is, because the sale itself is the sale of the goods. This is the whole problem we have with retail services in the first place. How do you distinguish the sale of the goods from the service? And so the way the case law proceeded was to say, well, you can distinguish between the sale of the goods and the surrounding service.
But there is still, it's still a requirement that the provider of the services is the one that's selling the goods. May have all these surrounding.
So your submission is that if I go into a supermarket, I have not received the retail service until I pay at the point of exit.
I don't think that's that. I think that's a different question in my submission, because you're looking at what the services are that the supermarket is providing.
Well, your submission was that there was no retail service unless there was a sale.
I'll reframe it. An undertaking is not providing retail services unless it sells goods to customers. And it's not providing, and the second point is that if all it does is...
But sorry, I'm struggling. You say an undertaking is not providing a retail service unless it sells goods to customers. But what's your answer to the hypothesis that I just put to you? I go into a supermarket, I wander around the supermarket, I see things that I like and I see things that I don't like, but I don't buy. Why am I not receiving the retail service?
Because the supermarket is offering goods for you to buy. So if the supermarket that you went into didn't actually offer goods to buy, so all you could do was go in and look around.
Some supermarkets offer a browsing period before you can make a sale. Are they not offering a retail service during the browsing period?
Not if that's all they're doing. So if that's all you can do when you go into a supermarket, then they're not providing retail services.
So there has to be the potentiality of a sale.
Yes, it has to be part of what they're offering. So if a supermarket is just a showroom, then it's not providing retail services. I mean, I can't think of one. But, and as I say, the second point is that it's not providing retail services if all it does is provide an auction service.
But in the case of an auction, there is the potential for a sale.
By the auction house. Yes, my lord. Not by Easylive Auction. Easylive Auction is not an auction house. It provides access to auction houses, to bidders, and bidders to auction houses. But it does not sell goods to anyone.
The requirement that provision of retail services must have the potentiality of the sale of goods. Where does that proposition come from?
The proposition that is in my submission the correct interpretation of retail services, and I say that because in my submission retail services is not a clear or precise term, and then according to the principle of interpretation of specifications, it follows that it must be confined to the substance or core of its possible meanings. And that is my submission as to what the core or substance of retail services consists in. and I say that is also supported by the appellant's, the EasyGroup's own reply skeleton. So if I could ask you to take that, which is in Core Bundle tab 9, page 70. Paragraph 3.2. So as I say, this is their reply skeleton. So in reply to respondents' notice points and the cross appeal, they make some preliminary points in the first section, and that is one of them in 3.2. And this is responding to a paragraph in our skeleton, which referred to this action being started 1.5 months before the trial of the first action between these parties. Saying no point should be taken about this. And I'm picking up 4 lines down. To the extent that a point is taken from Easylife's decision not to complain about the defendant's acts, they're the point that I was making, was that Easylife in 12 years of side-by-side trading had never complained of Easylife Auction itself before they sold their trademarks to EasyGroup. They say that is explained by the commercial priorities of that business, so the Easylife business, rather than from any examination of the strength of the defendant's rights. And they talk about Mr. Kaplan's evidence. So Mr. Kaplan was the founder of Easylife. He gave evidence for EasyGroup at the trial. Mr. Kaplan's evidence was that his concerns would have been with other catalogue-based retail service providers or operators of a retail website. So they say, well, the reason why Mr. Kaplan wasn't bothered about Easylive Auction was because his concern was with other retail service providers or operators of a retail website.
What's that got to do with the interpretation of the specification?
Well, here is a concession that Easylive Auction are not a provider of a catalogue-based retail service or operator of a retail website.
This is Mr. Kaplan's evidence about his concerns.
Yes, but this
How is the evidence of the subjective concerns of one businessman relevant to the objective interpretation of the wording of the specification?
Because I rely on this as a concession, my lord. This is EasyGroup conceding that Easylive Auction is not a provider of a catalogue-based retail service or a operator of a retail website.
Well, if the word other hadn't been there, it might have been, but the word other there doesn't support it.
Well, I'm going to come on to that passage in the cross-examination earlier, but he's not saying, I was worried about these people and not Easylive Auction because they were the other people were more significant in the marketplace. That's not what he's saying, but maybe we'll come back to that when I take you to the passage of cross-examination. So we say that the auction broadcast service is not a retail service for those 2 reasons. There's no sale by the provider of the auction broadcast, and in any event the goods are being auctioned, they're not being sold for a fixed price.
So how can that matter? Why is the fact that it's a variable price rather than a fixed price? Well, how can that make any difference?
Because that is, I say, a core component of a retail service. So
So if I go into a shop, it's a small corner shop, and the shopkeeper is prepared to bargain with me, then it's no longer a retail service.
That's not an auction, my lord. In my submission, that's not an
But
auction.
your point was it's not a fixed price.
I was saying that is not what Easylive Auction do. They only the auction houses that participate in the platform that use the auction broadcast services sell goods by auction, and that is it, not by a fixed price.
It's still a sale.
But in any event, the Easylive Auction are one step away.
Oh yes, well that's a separate point.
That's a separate point. You made that point already. I think my lord's question was just on the fixed price point.
It is my submission that if the means of concluding the transaction is an auction, then that falls outside the core meaning of a retail service. So that is why I say the auction broadcast service falls outside the scope of retail services. I also say that the catalogue service is even further away, because taken by itself, it does not even involve a sale at all. It is, again, the service which allows auction houses to upload their auction catalogues and auction event details on the defendant's website, where they can be viewed by customers. As I've been saying, retail services must at least involve a sale between the possibility of a sale. So just focusing on a catalogue service as a separate category of service doesn't involve
I'm a little troubled, and it's not your fault, Mr. Akins. I think both parties are equally to blame for the concern I'm just about to articulate, which is that we're being addressed on the meaning of retail services without any of the cases on retail services being cited or put before the court. And I find that quite troubling, as I'm very worried that if we pronounce on the meaning of retail services without having the case law before us, we're going to be per incuria.
Well, I have cited the Practicabile case,
Right.
which I say supports that. So that's in Authorities Bundle 1, tab 7. Page 133. And it's paragraph 34 that I've relied on. In that regard, it should be noted that the objective of retail trade...
Sorry, paragraph
34. The objective of retail trade is the sale of goods to consumers. That trade includes, in addition to the legal sales transaction, all activity carried out by the trader for the purposes of encouraging the conclusion of such a transaction. Activity consists in selecting an assortment of goods offered for sale, and offering a variety of services aimed at inducing the consumer to conclude the above mentioned transaction with the trader in question, rather than with a competitor. So that is what I say is the
Well, that's just
description.
that's just the starting point, isn't it? I mean, if we're going to look at this, I mean, we need to go through to at least paragraph 49. This is registration trademark covering services provided in connection with retail trade. Not necessary to specify in detail the services which that registration is sought to identify. As I said, sufficient to use general wording such as bringing together a variety of goods, enabling customers to conveniently view and purchase those goods. So you're absolutely right that purchase is in contemplation, but we find that it's necessary.
Well, it has to enable the customers to conveniently view and purchase those goods. That's an essential element of it. So yes, so I do cite that in support.
That passage is in quotation marks because it comes from
I think that is it's just in quotation marks because it's setting out what a specification might say. I don't think it's quoting from anything, but I might be wrong about that.
I understand. Thank you.
So it
Well, it actually comes from the explanatory note to class 35 of the meter classification.
thank you, my lord.
So it is a quotation.
Thank you, my lord.
Whenever I ask a question in these cases, my lord always has the answer. You could cut out the middlemen and just deal with the three of us.
That's why I didn't answer it with any confidence. We certainly say the catalogue services because they don't involve by themselves any purchasing or sale of goods, cannot be identical to retail services. And it's striking how the judge himself doesn't actually treat them, analyse them distinctly from the auction broadcast services. He addresses them together. The other point in relation to the catalogue services is that it's only provided to auction houses. It's assumed that the retails, that the auction broadcast services are identical to retail services because the consumer is the same. So it's the person actually buying the goods rather than the company undertaking that's selling them. That does not apply to the catalogue services. They're the auction house. So for those reasons, we challenge the judge's conclusion that the auction broadcast service and the catalogue services are identical to retail services. You'll have seen from paragraph 135 that the judge reaches the same conclusion in retail. He uses the same reasoning in relation to retail services he used in relation to the bringing together services. So we say the same conclusion must follow if one focuses on the bringing together services. But we also say that conclusion follows, you reach the same conclusion even if you treat and analyse the bringing together services in isolation. So again, looking at the specific wording of those, it's at paragraph 58 of the judgment on page 1. So these again, well, have to compare them, but it looks like at least the first part is a quote. It is the same as the quote from the guidance in the niece classification. So again, focusing on B(2) in paragraph 58, bringing together for the benefit of others a variety of goods, enabling customers to conveniently view and purchase those goods. It doesn't stop there. It's more specific, from a general merchandise catalogue, and then you have two means of purchasing, either by mail order or by means of telecommunications. We say that the Easylive auction, to the extent they're involved at all with purchasing of goods, it's not from a general merchandise catalogue. And then B(3), bringing together for the benefit of others a variety of goods, enabling customers to conveniently view and purchase those goods from a general merchandise internet website. Again, we say Easylive auction does not operate a general merchandise internet website. So, for all those reasons, we say the services are not identical, and that is a factor. The confusion is less likely than it would have been if the services were identical, if your lordships come to a fresh assessment. And that the similarity is only at a relatively high level of generality, in the sense that they are services in connection with the sale of goods provided online. The second respondent's notice point is similar in that it involves comparing different categories and descriptions of service. And it concerns paragraph 108 of the judgment on page 110. And it's the third sentence. It accepts that the Easylive stylized mark has an enhanced distinctive character as a result of the use that's made with it.
Pardon, I'm on the wrong paragraph.
Sorry, 108 on page 110. And yeah, so the first line, I accept that this establishes an enhanced distinctive character for the Easylive stylized mark. And then we have the sentence that was the subject of ground 2. And then third sentence, I have to say that I am not certain whether it would be correct to say that the enhanced distinctive character was limited to the business actually conducted under the Easylive name, which Mr. A. See paragraph 98 above, was quite different to that being conducted by the defendants. Sorry, that's my argument. But even if it was not so limited, so even if the enhanced distinctive character was not limited to the services provided by Easylive, do not accept that in this case it would lead to likelihood of confusion.
So you argued that the enhanced distinctive character was limited to the business actually conducted.
That's right, yes.
And the judge says he didn't know whether that was correct.
Exactly, yes.
And so your second respondent's notice point is what?
My
He had found that it was correct.
My second respondent's notice point is that yes, my argument here is that it was correct. So that the enhanced distinctive character that he has found should be limited to the services in relation to which the Easylive mark was actually used.
Right.
Which was the general merchandise catalogue business and the general merchandise retail website. And we question as a matter of law whether it is open to a judge to find that the enhanced distinctive character expands beyond the actual use. Certainly my learned friend wasn't able to point to an authority.
Can you point to an authority in the opposite direction?
That's why I phrased my submission in the way that I did.
Astounded. There seems to be no authority either way. One would have thought that was clearly established one way or the other by now. So intriguing.
But perhaps the reason is this: is that it's established as a principle. We looked at it under ground 2. That if the mark has enhanced distinctive character, then that makes confusion more likely. Now, if that's the case, then actually it's a bit artificial to consider the extent of whether the enhanced distinctive character extends beyond the use that's been made of it. Because what matters is that the mark has enhanced distinctive character in relation to those services. That makes confusion more likely.
So why does it matter?
Yes. It matters because the judge has. Yes, I mean this is a protective point. Again, if you're conducting the assessment afresh, what I'm trying to prevent is a situation where I have not challenged an assumption that by the judge on which he proceeded, which was that the enhanced distinctive character is not limited to the use that was made of the mark. We say that it is questionable whether as a matter of principle that is allowed, and certainly in this case it shouldn't be, because the use that has been the use of Easylive over the last 25 years has been very specific.
Sorry,
has been very specific.
Specific services.
Yeah, in relation to the catalogues, the retail catalogues and the retail website.
Let's can we test the argument by reference to Mr. Peterborough's hypothetical example? So he postulates an example where the trademark is registered for magnets. The only magnets that have been sold are blue magnets. And they've been sold in vast numbers. So there's an enhanced distinctive character by reason of the sale of the blue magnets. Now, your argument is that doesn't affect the distinctive character of the trademark, even if magnets are sold which are red. Why not?
My argument is that when considering the enhanced distinctive character and the effects on the likelihood of confusion, you only consider the actual use. So in those
You're raising a point of principle. You tell us there's no authority either way.
Yeah.
And so I'm trying to explore the principle. If the public had been educated through the use of the trademark to associate it with magnets, why does it matter that the extent of the use is purely in relation to blue magnets?
I think my response to that is that it's a bad example in the sense that that's an arbitrary subcategory.
Right.
And so blue magnets.
So how does one draw the distinction for this purpose between subcategories that are arbitrary and those which are not?
Well, because that's a blue magnet. Blue magnets wouldn't be perceived by the average consumer as a significant category.
All right, well, let's vary the example. Suppose that it's washing machines, and the only washing machines that have been sold, I don't know, have certain types of settings, and not all types of settings are available on that. Suppose, for example, for some bizarre reason, there's no co-wash on that particular model. Does the reputation not extend to all types of washing machines?
Again, I would say that that's an arbitrary. That's an arbitrary
Well, it might
subcategory.
be arbitrary to the consumer of the goods. They might be quite
Well,
concerned
it's something
as to
that you
whether they
look
were
for.
getting a cold wash setting or not.
It's a feature that you look for, certainly, when deciding whether to purchase a washing machine from one company or another. But you're looking for a washing machine. That's how you do it. That's the activity of the average consumer in that case, and that's what they're concerned with. So
So that would suggest that what we're looking for is the impact on the consumer rather than an unduly close focus upon the nature of the activity.
Well, I think we're looking at what the average consumer would perceive as the relevant category of services or goods or services.
But that's what I'm jibbing at. Why? I mean, you can understand that it's the impact on the consumer's perception of the mark, to be sure. But why, for this purpose, are we concerned to drill down into the consumer's perception of the goods or services?
Well, because the distinctive character of the mark will only be enhanced in a category of services perceived by the average consumer. So if they perceive that, so they will only regard that mark will only have become more distinctive within a recognised category of goods or services by the average consumer. It won't extend beyond that because it just won't have it won't have trespassed outside that. That's the point that I'm making. So that is.
Suppose the trademark has only been used on hardback books. Will the consumer not think that trademark has meaning in relation to paperback books, even though it's never been used?
Again, I don't think that is an appropriate subcategory. So I'd say they would regard it as having an enhanced distinctive character in relation to books. Because you want to buy a book and you may prefer a hardback, but it's likely that you would also be looking at paperbacks. And so the trademark that is used in relation to those can become more distinctive in relation to the general category. But I think that those examples are quite a long way away from here, because the issue that's before us is that if I am wrong about the in the first respondent's notice point, such that the auction broadcast service and or the catalogue service are within the scope of retail services, then the question is, well, has the use to which the Easylive marks are being put resulted in an enhanced distinctive character of that mark in relation to services which encompass the auction broadcast service and the catalogue service? So that's where it becomes relevant. And so in my submission, if I'm wrong on the identity of services, and it is sufficiently wide, it hasn't become, the Easylive marks have not become more distinctive in relation to auction broadcast services and catalogue services, because they are sufficiently different, even if they are encompassed within the wider term of retail services.
All right, so that's the second respondent's notice point.
Yes. So
are you then coming on to the cross appeal?
Yes.
Or shall we take the 5 minutes for the transcribers now?
Court rise the favour.
Yes, the cross appeal.
Yes, my lords. This concerns the counterclaim for revocation of the Easylive stylised mark on the grounds of non-use. There are two grounds. Ground one is a challenge to the judge's decision that 4 of the variant forms relied on did not alter the distinctive character of the stylised mark as registered. That ground is successful, then the mark is revoked in its entirety. Ground 2 challenges the judge's decision that the use to which the variants have been put justified retaining advertising services and promotion services in the specification. We say they had only been used in relation to a narrow subcategory of services, so even if the judge was right on the variant issue, the mark should be partially revoked insofar as it is registered in relation to advertising services and promotion services.
Yeah.
So ground 1 on the variants, the judge says, so the mark, just to remind you of the mark, it's in paragraph 7 of the judgment, page 88 of the court handbook.
Yeah.
And the variants relied on were set out by the judge in the table at paragraph 47 on page 97.
So, yeah.
And the issue for the judge was whether the use of these variants was use in a form differing in elements which do not alter the distinctive character of the mark in the form in which it was registered. And on the law, there is no dispute as to the general principles to be applied. Those were set out by my Lord Justice Arnold at first instance in the Walton case, drawing on the judgment of Lord Walker in the Budd case. And they are set out by the judge in paragraph 40 on page 94. In subparagraph B, he sets out the 2 parts of the necessary inquiry. First, to identify the points of difference between the markers used and the markers registered, and second, to ask whether those differences alter the distinctive character of the mark as registered. And in C, the normal approach to the assessment and comparison of distinctive character applies in this context. Those principles are at a relatively high level in my submission, and it follows that there is some room for differing outcomes applying them. And you see that in the Budd case itself, and the mark and variance compared are set out in paragraph 42 of the judgment on page 95. And to describe what happened in that case, the hearing officer at the UK Intellectual Property Office, Mr. Salthouse, held that the distinctive character had not been altered by use of the sign used. Then on appeal to the High Court, Simon Thorley QC, sitting as a Deputy High Court judge, disagreed with him, held that the distinctive character had been altered. Then the Court of Appeal, Lord Walker in the Court of Appeal, said if he had been making the decision himself at first instance, he would unhesitatingly have come to the same conclusion as the deputy judge hearing the first appeal. So in other words, that the distinctive character was altered. But he did not have a free choice as an appellate tribunal, and neither did the judge at the first instance appeal. Hearing officer had not made an error of principle, nor was his decision clearly wrong, and therefore the decision stood that the distinctive character had not been altered. So that shows how tribunals can come to different conclusions applying the general principles. But it also shows that you can't take a wider principle from the Budd case.
Yeah, can I just ask a question about that? Because my memory of the case is particularly the first instance decision isn't precise, but am I right in thinking that the focus of the inquiry, the way it's shown here, you might think that the inquiry was concerned with the totality of what's on the right-hand side. But I don't think it was. It was purely with the Budweiser-Burnbrow element. Because, as we all know, it's possible for there to be more than one sign or trademark within the same field of view. Am I right in remembering it in that way? Certainly the way the deputy judge describes it in 43 would be consistent with that, but I don't know if my recollection is correct.
Well,
Different font and absence of underlining. So the fact that there's additional features was disregarded.
just let me make sure I understand.
Well, take the castle, for example. You know, I think there's 3 towers of a castle or something like that in the middle.
Yes.
That could be a separate trademark altogether.
Yes, but I don't think that he held that the sign was not the sign that you see there. So the variant was not the variant that you see there. I don't think that that's what the hearing officer held.
Well, but you know, because of course this is all before the subsequent cases in the Court of Justice.
Yes.
Where this question is explored. But as a matter of principle, I assume you would accept that you could have a case where you've got the registered mark, and then what's used is a variant of the registered mark together with something else.
Yes.
Yeah. Thank you.
Yes. Okay. but I think yes. But the submission that I am making about the Budd case is you can't take the wider principle, which is that in all cases where the mark has a word element, or the mark is a word element, which has at least some distinctive character, and that word element is used in a variant, the use of the variant will not alter the distinctive character of the mark as registered. I don't think EasyGroup goes that far, but in some of their written submissions at least, they're pushing in that direction. We say that's also illustrated by the one aspect of the Walton decision itself. I'll ask you to take that. That's in Authorities Bundle 2, and 14. And the aspect of the decision I want to focus on is the analysis in relation to the EU 044 mark. And that is set out, shown in paragraph 3, little 4 on page 627. That's the last mark there. So you see it's the word Giordano with what is referred to as the domino, within the domino logo. And it's registered for goods in class 14, which levers is watches and such like. So one of the issues was whether this mark had been put to genuine use. And the section on revocation starts at paragraph 110 on page 652. The section on the law is the section that's cited by the judge and is common ground for setting out the principles. And the assessment in relation to this mark starts on page 667, paragraph 174. So this is the assessment of two marks, UK 444 and EU 044. I should say the UK 444 is just the word Giordano. And then 175 it is dealing with the facts. It talks about an invoice in Germany, on delivery of products to Germany. Then over the page, 668. Last sentence of paragraph 175. Remains the case that the invoice establishes the sale and shipment of Giordano watches to a distributor in Germany. What it does not establish is use of the domino logo, which is the subject of EU 044. And then in 178, this addresses here, my Lord Justice Arnold, addressing the variant issue in relation to EU 044 from the second sentence onwards. As for EU 044, there is no evidence of use of the domino logo within the relevant period. While there is evidence of use of Giordano in Germany, I do not consider that amounted to use of EU 044 in a form differing in elements which do not alter its distinctive character. A significant part of the distinctive character of EU 044 derives from the domino logo, even if the dominant element is the word Giordano. So I rely on this as showing that, as a matter of principle, the distinctive character of a mark as registered can be altered by use of a variant, even if the dominant element of the mark as registered is used in the variant. And indeed, even if the variant consists exclusively in the dominant element, as was the case here. Now, each case turns on its own facts, but that is a possible outcome. And the way I put our case on this appeal, on ground one of the appeal, we say that the error that the judge made was a lack of consistency between his assessment and decision on the variant issue under section 46.2 and his other findings in relation to the stylized mark, in particular when considering infringement. And in particular, I rely on the following parts of the judgment. First, paragraph 87, on page 105. this is where the judge is comparing the defendant signs to the Easylive stylized mark for the purposes of infringement. It says another important difference, visually and conceptually, is that none of the defendant signs include anything even remotely resembling the triangular device containing a tick that is a feature of the Easylive stylized mark. As I found when dealing with the issue of revocation, that device served to emphasise the concept created by the word Easylive. It would be seen by the average consumer as an important part of the mark. Its absence from the signs is therefore a significant difference, as I have mentioned, highlights the different conceptual message that the signs convey. And
Why is that inconsistent?
well, if you compare that to paragraph 56, then 56 is considering whether the word Easylive by itself is a permissible variant, so whether that alters the distinctive character of the mark as registered. It says sign 5 uses simply the word Easylive without any stylisation, omits the words lifestyle solutions. However, I do not believe, in capital letters without stylisation or any of the figurative elements of the Easylive stylized mark. Also omits the lifestyle solutions. However, I do not believe those words will be seen as particularly significant by the average consumer. Hold that thought. And given my conclusion that the word Easylive has some distinctive character and is the dominant element, I'm satisfied that use of sign 5 constitutes use of that mark. So he doesn't consider expressly in this paragraph the tick, the triangle, at all.
This is in circumstances where he has considered it previously. And
That's
he's working
perfect.
through, starting with the sign that's most similar, and ending up with that which is least similar.
That is fair. But he's losing sight. It's in my submission, it's too incremental. He's losing sight of he here is losing sight of the actual comparison at hand, which is between the mark as registered and Easylive, the word. And that is to hold that the distinctive character hasn't been altered here is inconsistent with what he said about the absence of the triangle when it comes to the defendant signs.
Well, he takes the view that it's a tick. And so when he compares it with signs 1, 2 and 3, he says, yes, it's different tick, but it's still a tick. And I take your point. You say, well, he's lost sight of that difference when he comes on to 56, albeit the progression of reasoning, as I've already pointed out, is from the most similar to the mark as registered to least similar to the mark as registered. But suppose he's wrong in 56, why does it follow that he's wrong earlier?
Ah, right, in relation to the tick ball, the tick ball variance. So there, in the, sorry, I was going to make a point about the strap line as well, before we get there. So he's also deems the strap line, so lifestyle solutions, significant for the context of the infringement analysis in 88. Where it says, finally, the average consumer would note other differences, albeit of lesser distinctive significance, such as the omission of the words lifestyle solution, the inclusion of additional words. So he's not saying, and I say this is a finding, that the strapline lifestyle solutions is of some distinctive significance. And the EasyGroup aren't challenging that aspect of his decision. So the triangle and lifestyle solutions are of some distinctive significance. And we say that should be enough for their absence then to alter the distinctive character or alteration. in relation to the tick ball specifically, my submission is that that was not a conclusion. So the conclusion that the addition of the tick ball in the tick ball variants did not alter the distinctive character of the mark was not a conclusion that was open to him based on the evidence of Mr. Kaplan specifically. And
And why is the judge obliged to surrender his judgment to the evidence of any witness?
because Mr. Kaplan, it's his company, he founded the company, he's been there for 25 years. He is the best person of the people who are giving evidence to give evidence on this issue. He can be taken to know his consumers. His evidence was that it was a constant feature of their branding for 25 years, to the extent that when they became a licensee of EasyGroup, they got a special carve-out of their license agreement so that they could continue using the tick ball, albeit in orange and white, even though that is a clear departure from how other EasyGroup companies.
That's on any view irrelevant because it's after the relevant date.
Well, but that the reason why he did it was because his customers associate the tick ball with Easylive, and so it has strong distinctive significance. And even if you take the view that the triangle contains a tick, it is different in appearance to the tick ball. Triangle was never actually used in commerce.
So just that I'm clear, is the sentence you object to in paragraph 51 that says, accordingly, notwithstanding Mr. Kaplan's comment.
Yes. It's
You
just
say-
You say that finding wasn't open to the judge.
yes,
Why? This is the question I asked you earlier.
because
Why is the judge compelled to surrender his judgment to the judgment of Mr. Kaplan?
because that is the strongest indication that the judge had as to the perception of the average consumer, and he had nothing else.
I understand it to be law supported by the highest authority in this jurisdiction, that it is the responsibility of the court to form its own assessment, not to surrender its judgment to that of a witness. It's a general proposition across many areas of the law, but if you want it in specifically in the field of trademarks, we have the House of Lords and GE.
My lord,
So what's the answer to that?
my lord, I say it's not a reasonable conclusion to come to in the face of that evidence and nothing to the contrary, nothing supporting his view. Is the conclusion that he has made. So there's
Right,
evidence
so
on
you
one
put
side.
it as perversity.
Yes, yes, my lord.
Okay, that I can understand.
It wasn't open to him taking into account the evidence as a whole. And there was no evidence that anyone ever made a link between the tick in the triangle to the tick in the tick ball. So those are my submissions on ground one. Ground two regards partial revocation.
Yeah.
And we say that advertising services and promotion services in the specification should be removed and should have been removed and replaced by providing advertising or promotional space in printed publications in light of the narrow subcategory of services to which the mark was actually, in relation to which the mark was used. That is the narrowed specification that Mr. Justice Fancourt arrived at in Easy Fundraising
Subsequently.
subsequently.
And I appreciate you say he was right about that, but am I right in understanding that the judge in our case, in the present case, rejected that? And I'm just sorry, I'm trying to remember. Yes, he does. Yes.
Yes. So he
so
upheld.
So that was he records that being put forward at 73.
Yes, it was slightly different. It was more so
It was not the identical wording.
Exactly. Yes.
So you say the point was the same.
The point is the same. The specification that Mr. Justice Fancourt arrived at was slightly broader than that was proposed by the defendants in that case and the defendants in this case. And of course, the other thing to note about Mr. Justice Fancourt's decision is that was obiter, given he had remote the mark in its entirety, having decided against EasyGroup on the variance point. But focus
But to be clear,
yes.
as I understand it, you are content with Mr. Justice Fancourt's formulation.
That's right. That's what we're advancing in this case. I've advanced it as an alternative in the grounds of appeal if it was said against me that it wasn't open to me to advance a different specification on appeal to that which I advanced below. But that point isn't being taken, so we endorse Mr. Justice Fancourt's framing of it. And the ground of appeal, ground 2, is very simple. It is that the judge did not ask himself or determine what a fair specification of services would be, having regard to the actual use that had been made of the variance.
Sorry, did not ask himself or determine what?
A fair specification of services would be, having regard to the actual use that had been made of the variance. It's common ground that he was required to ask himself that question and determine that question. And that comes from Lord Justice Kitchen, as he then was, his judgment in the Merck case. And it's the relevant passage is quoted by the judge in paragraph 69 on page 101. See, there are 4 steps to the analysis. And the last sentence of paragraph 248 of Merck says, ultimately it is the task of the tribunal to arrive at a fair specification of goods or services having regard to the use which has been made of the mark. It's common ground at trial that was good law. Subsequently, Lord Kitchen said in the Skykit case that passage in Merck needed to be read in light of the judgments of the Court of Justice, and those included the ACTC case, which the judge quoted over the page on 102. See, which Mr. Edinburgh also referred me to ACTC. And that talks about the court has held in essence that the criterion of the purpose and intended use of the goods or services at issue is an essential criterion. But I understand it to be common ground on this appeal that the purpose of goods and services is important but not determinative. So you still need to ask what a fair specification would be. And we say that the judge failed.
Why do you say he didn't ask himself the question? Because at the end of 73, he records your argument.
Yes.
That a fair specification, one reflecting the use made of the mark would be, and then that's the formulation that we were looking at a moment ago. And then he rejects that.
Well, he rejects. So in 74 is concerned exclusively with the purpose and intended use of the services.
Why is he not saying that the fair specification is the broad one?
Is the what? Sorry.
The broad one.
But because he's only considering the purpose and intended use at that point. So at the end of that analysis, he doesn't then ask himself, well, what's a fair specification? I'm not saying he shouldn't have done what he did in 74, but it's just missing a step.
Even though at the tail end of the preceding paragraph, he recognises the need for that.
Well, in my submission, that's not what he's doing. He's recording a submission. That's not the same as recognising the need to ask himself that question.
Okay.
So, and that's in contrast to what Mr. Justice Van called my submission. So we say it falls to be assessed. There falls to be a fresh assessment in this case.
Let's assume you're right, he doesn't get to that final stage. It might be suggested the reason for that is because of what he says at the end of 74. Rather than being indicative of a different or distinct category of services. So in other words, he's saying there's no subcategory here.
Yes, and we say, so we say, he hasn't asked himself the first, what a first
Well, why does he have to do so? If there's no independent subcategory, why does he have to do that? Because he's got the wording of the specification.
Well, in my submission, that's not what he's doing in 74. There, he's just looking at the purpose and intended use.
But that would suggest that he's doing the exercise mandated by ACTC.
Yes.
In order to see if there's an independent subcategory, you focus upon purpose and intended use. So that way of reading it would suggest that he's saying, no, there's no independent subcategory, and therefore you stick with the wording in the specification.
When applying that criterion, he arrives at that conclusion. But Merck still says you need to ask yourself what a fair specification was. So even if, having applied the ACTC test, you haven't identified a subcategory, you still need to ask what a fair specification is.
Why? Sorry, that's the bit of the argument I'm not following. So, let's assume, for the purposes of this question, that what the judge has done is to make a finding that there's no independent subcategory. Therefore, the only category is advertising services, and with that, he has no basis for departing from the wording in the specification. Why? On what basis do you say that he is obliged to frame a fair specification if there is no independent subcategory against which to frame it?
Because that is not the only consideration. So, in other words,
But isn't this
you can
the
still
whole point that Lord Kitchen was making in Sky? This is why, is it not? You uttered the words of caution that he did, because we only get into this debate if you've got an independent subcategory.
But if you can, you obviously can identify an independent subcategory of advertising services. I mean, Justice Fancourt does it. Easy fun.
Yeah, the argument is that he was wrong. So that's one of the things that we have to decide is who's right.
That's not right. So the question is, by what criterion are you doing that? And if so the question is, well, is the only criterion in town the purpose and intended use of it? In which case, the independent subcategories that you arrived at applying other factors are to be discounted altogether. And the difficulty is that applying this test, purpose and intended use, is inherently imprecise. My submission just depends on the level of generality that you consider purpose and intended use. Advertising services, in my submission, is similar to computer software or financial services, incredibly broad category. And in order to conform with the policy of partial revocation, which is that just because a trademark proprietor
Yeah,
is
well, as you know, you're preaching to the converted on that score, but presently I'm a lone voice. Unfortunately, despite me having spilled a fair amount of judicial ink on the proposition that you shouldn't have a registration for computer software, registries across Europe and in this country are still doing it.
yes, but when they're challenged, then there is sound basis in law for doing that.
No,
Revocation.
no. The challenge is bad faith. That's how you challenge a registration for computer software.
Yes, but it hasn't. If it hasn't been used, if it's only been used into a specific piece of computer software, then you can
you're
revoke
right.
it.
You're right. I misspoke. In that specific instance, you may be able to identify independent subcategories of software. Yes.
Yeah. So advertising services, as I say, it's incredibly broad, as Mr. Justice Fancourt found. It is possible to identify distinct subcategories. It's common ground that purpose and intended use are not the only factors to take into account, and that standing back at the end, you have to ask what a fair specification is, having regard to the use that has been made of it. So if you do that in this case, then the only use to which this mark has been put that counts as advertising services or promotion services is a very specific catalogue insert service. It cannot be advertising services having regard to that use cannot be a fair specification for it on any
Well,
view.
that submission I understand, but that's going to say that the judge has reached the wrong conclusion in 74, because the substance of that point is to say, well, actually, when we look at advertising service, there are different types of advertising services. Go back to your analogy of computer software.
Yes, well, that's certainly my submission.
Yeah, okay.
So if I'm right about that and the ground 2 is successful, then the consequences are that when considering infringement of the stylised mark afresh, you have to consider notional and fair use of that mark in relation to the narrow subcategory, rather than advertising services. If Mr. Justice Fancourt's narrow specification is adopted, then again that the advertising services that defendants provide will not be identical to that narrow subcategory of services for the Easylive stylised mark, and that feeds into the likelihood of confusion analysis. So for all those reasons, we say the appeal should be dismissed. If it is allowed, the stylised mark should be revoked, alternatively partially revoked. And even if it isn't, the infringement claim as a whole should still be dismissed according to the parts of the judge's original reasoning, which are unchallenged, and because of the points raised in the respondent's notice.
Thank you very much. So, I'm just going back to my notes of the but I'm going to tick some things off. How about that? So you're going to reply,
Yes.
and you're going to answer the
Cross appeal.
cross appeal. You've
Both
already
aspects.
dealt with one of the additional ground point,
Yes.
and you'll address one of those, and your junior will address one of those.
Yes.
Yeah, fine.
And the third has dropped away, so that's the invalidity of the 904 mark.
Yeah.
That's gone.
Yeah.
So dealing with that in the same order,
Yes.
with respect to my reply, I only have one point, and that is that with respect to the examples of purported confusion, you saw that there are 86 examples in the supplementary bundles. my learned friend asked me, or asked my junior rather, which examples I was going to draw to the attention of the court, and I gave that indication on Monday morning. So therefore, he had some forewarning as to the sort of way in which I was going to develop the argument before your lordships. So there was about 20 odd examples, so that's clearly more than the 7 examples that are only detailed in paragraph 119. With respect to excuse me, the cross appeal, the first point is the unacceptable variant.
Yeah.
Now, the way in which this was developed in the skeleton argument that was put forward against me by the respondents is that you could only, in essence, look at the dominant parts if the other parts were negligible. Now, that's not the way in which it was run below, but allowing that this might be argued here, you'll recall that when I took you to the test with respect to whether or not there's a conflict between marks and signs, the first 2 sub-paragraphs that I drew your attention to related to the dominant component parts and whether or not you could only rely upon them, and you could only do that if the other bits were negligible. The reason I drew your attention to that is because that's the test that occurs when you're comparing the mark with the sign. And so that is a test that is appropriate for that comparison. But what we say here, when you are looking at whether or not a variant is acceptable, the relevant wording is contained in section 46, subsection 2, differing in elements that do not alter the distinctive character. And so therefore, what one is doing when you're looking at the mark as registered and the variant as used is a different thing. You're seeing whether or not in the variant you have the same distinctive character as in the mark as registered. And therefore, it's a slightly different test. And therefore, whether or not other bits in the registered mark have not been used, or whether other things in the variant have been used, you don't have to determine whether or not they're negligible before you can dismiss them in the analysis. It's a completely different analysis. And my support for that comes from the Sony case, which is in the second authorities bundle. At tab 15, and I'd like to pick it up, if I may, at paragraph 47, which starts at page 427. Now, I'm afraid I'm not going to take you through the whole thing now. You can see that what's been sidelined is 44 through to paragraph 54. But if we just focus for the moment upon 48, it says the word element had a high level of distinctive character and occupies an important position in the overall impression created by the contested mark as registered, whilst the figurative elements have only a weak distinctive character and occupy merely an ancillary position in that overall impression. The point being here is that those other elements that had a weak distinctive character did not affect the distinctive character of the mark as a whole. And it's important to note from my submissions that it's not that those other bits had negligible distinctive character. They clearly had some, but it wasn't enough to alter the distinctive character of the mark as registered. And if I might cut to the quick, if you turn to the page, so I'm still behind tab 15, but this time at page 428, paragraph 53, in the fourth place, it must be held that the applicant cannot complain that the Board of Appeal applied in this case a criteria of overall impression. According to the case law, it is relevant to examine whether the differences between the mark used and the mark as registered are capable or not of changing the overall impression created by the mark. So what I'm trying to draw here is that when you're looking at a mark and the variance, you need to focus on the overall distinctive character, and that's quite the right approach. You don't have to say, a bit's missing, and that bit that is missing is not negligible, or a bit has been added, and that bit is negligible. You can have things that are more significant that are either added or taken away, and you can still retain for an acceptable variant, so long as the overall impression is the same. There's also here in 51, you get evidence or support from our proposition that if you're using the word of a mark, then that's sufficient, basically, because that's, of course, the core part of the mark as registered. So that's my central submission. The point was raised with respect to some of the evidence from Mr. Kaplan. My Lord Justice Arnold already dealt with this. But what's important to note is that even though the evidence was that it was a constant feature, this is with respect to the tick ball, that's slightly different from saying that it was something that contributed to the overall impression. It might be constant, yes, but the evidence didn't go further. And in this particular case, the things that have been dropped are the tick, the eye, the tick that's contained in the little griff over the eye has been mutated into a tick ball in front. But that's a sort of laudatory type thing. Or the strap line has gone. Again, that's pretty laudatory and or of not great importance. And we say that this is all completely consistent with, for example, Budweiser. There's a point here, it's not recorded in the judgment with respect to a graphic as to what the variant was. If your lordships would like, I can get you that graphic, because I was in
Is
that
it
case.
not the one that's reproduced by the judge in our case?
Sorry. Is it the one that
The
shows
one
the
that
neck
to the
label?
naked eye looks as if they have nothing whatsoever to do with each other except for the same words.
My lord, I might not comment upon that. If it's the neck label, then that's it. It is electric. Oh, sorry, it is. Sorry, that's okay then.
Okay.
Yeah.
It's the one on page 95, isn't it? Paragraph 42.
Sorry, I've just
Paragraph 42 of the judgment, is that what you're talking about? That's right, isn't it?
yes.
Yeah.
That is it. Yes, it's not recorded in any of the reported cases. That's the peculiarity about that point.
Oh, the judge has found it from somewhere.
No, I gave it to him.
Ah, right, okay.
Sorry.
That's why it's there. Fine.
Yeah, that's why it's there. Yeah, sorry. I'm sorry, I forgot that it was there. The next point is also, in Budweiser itself, at paragraph 45, it talks about the global appreciation. So I say that resonance with the overall impression point that was in the Sony case. And further support for use of the verbal element alone can be found in the Waxter case. That's in the fourth bundle of authorities behind tab 33, and it's paragraph 92, which is on page 1117.
fourth volume.
Volume 4 of the authorities,
Yeah.
tab 33
1117.
and page 1117. Now, there's a problem with this reproduction. There's two problems with this reproduction. You can see the official translator's stamp at the bottom right-hand corner.
Hang on.
Sorry, my
With
lord.
tab 33,
Yes.
it starts 1146.
It's page 1156.
Thank you very much. My lord says it's page 1156.
Oh, I see what you. Sorry, I was taking you to the stamped version, and the better version that's clearer is on page 1156,
Paragraph.
92.
Yeah.
Sorry, is there a translation here?
Yes, if you just follow it through, my lord, you see this is a translation, but the point is there's a translation that's got an official stamp on it.
But what's the difference?
The point is the stamp actually obscures some of the relevant wording.
Right, okay. But sorry, why is there not an official translation?
Oh, no.
No,
It's only
we had to
French
get
and
this for the case.
Okay, okay,
Sorry.
now I'm understanding.
Sorry.
Right, sorry.
Sorry, can you give me the page reference
Yes.
again?
Bundle 4, tab 33, the unstamped version is on page 1156, paragraph 92,
Thank you.
and the stamped version is on page 1171.
Yeah.
And the reason why I'm drawing that to your attention is because, unfortunately, the stamp obscures some of the relevant
Yeah,
words.
so it does. Right, now I
And the
understand.
And the second point, my lord, is that when you go to page 1172, there's a line missing. It's been photocopied badly,
Right, okay.
basically.
All right.
So it's all there in the unstamped version.
Right.
But the point here is paragraph 92 says if the mark contains a word, then the word is the most important mark. And so, in summary,
Are you saying
sorry.
that's a general proposition? I mean, they took the view on the facts of that case. But is that always going to be true?
no, it can't be always true, but I'm relying upon it in support of what I'm saying. And for example, with respect to Budweiser, as my Lord Justice Coulson put to me, so to speak, hopefully rhetorically, that I don't have to address him in detail on it, with respect to the neck label on Budweiser, every case depends on its facts.
Of course.
But I'm trying to give you some examples that support the proposition that I'm putting forward generally.
Yeah.
And the other points that were basically made in this context can be addressed very briefly, we would say, that the relevant question here is one of comparing the registered mark and the variant. It's not the same purpose as the test that's outlined with respect to a conflict between a mark and a sign. And the important point there is that you can have some differences so long as it does not affect the overall character, the overall impression. Lord, that's all I was going to say on that point, if I may. That brings me to the partial revocation point. And,
Can I just
sorry, yes.
ask you this question? I mean, Mr. Aikins focused his argument on the fourth and fifth variants. He also attacked 1, 2, and 3.
Yes.
But the majority of his submissions were about 4 and 5, and in particular 5.
Yes.
Suppose we took the view that number 5 was not a permissible variant, but 1 to 4 were, or even we took the view 4 and 5 were not permissible, but 1 to 3 were. What would that matter?
you would then have to drill down into the evidence that each of those variants, evidence of use that each of those variants supported. That was all produced before the judge, but is not before you.
But when we look at his reasoning on extent of use, to what extent does it depend on
5 alone, for example.
overlap?
From the judgment, I don't believe has done that analysis variant by variant because he felt it was unnecessary. So, in short, I can't give you a detailed answer to your lordship's question because I don't have all of that scheduled for me.
I mean, one can see, I mean, if one looks at page 100, I mean, some of it, so paragraph 65 is focusing on sign 4. So if sign 4 is not a relevant variant, then that conclusion will stand. By contrast, in 66 and 67, he's addressing signs 1, 2, and 3, and whether they've been used as well as the admitted use of sign 5, and the conclusion at the end of 67 is yes, they have. So on that footing, it might not make any difference if in fact sign 5 goes out because it's not an admissible variant.
But that is one of the reasons why I was putting forward the proposition that the use of the word alone was sufficient. So
Well,
as to say 5,
I'm not-
you've done that. You've
I'm
done
not prejudging the question of,
No.
of which variants are admissible. What I'm looking to see is what we need to decide.
Yes.
Well, it might be helpful if I can interject at this point. It's not, in my submission, it doesn't make a difference. So in other words, the judge has found that variants 1 to 3 have been used in relation to all relevant services.
Right.
So if variant 5 is not a permissible variant, that doesn't affect the overall decision on revocation.
Well, that's helpful. What about 4?
4, he's held that that's not used in relation to the insert service.
Okay, right. So it doesn't matter.
That doesn't matter either. Right.
So therefore, you have to win on 1, 2, and 3.
Yes.
That's very helpful clarification. Thank you.
I should just add in this case.
In this case,
Yes, I'm grateful for that. Right. Then I was going to move on to the partial revocation point.
Yes.
What we basically say here is that the judge clearly had in mind the relevant test because he quoted Merck. Then the next point is that he also quoted ACTC, which is obviously a pertinent care test, as shown by the Skykick case. You have to take Merck in the light of ACTC. Then you need to look at whether or not there is any acceptable subcategory. And if there's not, there's nothing more that you need to do. But if you do find a subcategory, then in essence, that is the way in which you reach a fair specification. And in this case, the way in which you work out whether or not there's a subcategory is you see whether or not there's any different purposes and intended use. And you get that from ACTC, paragraph 44. And here, unlike financial services or unlike computer services or computer programs, really there is a sole purpose to advertising, namely advertising. Trying to advance the sales and the promotion of the product or services that are the subject matter of the advert. And the sort of divisions that are being put forward for you are not proper divisions with respect to the intended purpose or the intended use. Rather, they are difference in the ways in which that purpose can be delivered. And so, to put it in a different context, it'd be wrong to say that you can deliver certain goods and services through only retail shops at stations or what have you, as opposed to on the high street. That's dividing it in an impermissible way. For financial services, there's clearly a vast number of different financial services out there. There's obviously accounts, current accounts, savings accounts, other saving instruments, mortgages, all sorts of different things. With respect to computer programs, again, there's a whole load of obviously different things there. Some computer programs run other pieces of equipment. Other computer programs are used for things like providing software for word processing. And in that context, my Lord Justice Arnold would be interested to know there's a draft practice amendment notice coming out in the next month or so on the UK IPO's stance on Skykick vis-a-vis computer programs.
Oh, right.
I'm not sure it's going to make very
forward to
interesting.
reading that with interest in due course.
Well, I was just going to say you might not find it very interesting.
Right.
But anyway, you can put that on your list. But might I please go to the ACTC decision, which is in Authorities Bundle 2. And it's behind tab 20. And this time the relevant bit for my purposes, paragraph starting at 51, page 705. Now, to put this in context, this was with respect to an application to narrow down the specification for clothing, and the use had been used upon, in essence, waterproof clothing. And in 51, it indicates that the goods concerned have several purposes and intended use. Determining whether there exists a subcategory of goods by considering in isolation each of the purposes that these goods may have is not possible, contrary to what the appellant claims. Indeed, such approach would not enable independent subcategories to be identified coherently and would have the effect, as the AG noted, of limiting excessively the rights of the proprietor inter alia, in that his legitimate interest in expanding his range of goods or services for which his trademark is registered would not sufficiently be taken into consideration. And in 52, the General Court was therefore right not to take into account each of the uses of the goods at issue to cover, to conceal, adorn, protect the human body in isolation. Those different uses combining for the purposes of putting those goods on the market. And then 53, the second complaint of the appellant claimed the court failed to take into account the fact that the goods were aimed at different publics and were sold in different shops, must also be rejected as unfounded, insofar as such criteria are not relevant for defining an independent subcategory of goods, but for assessing the relevant public. The point being there is that yes, it is possible in some senses to limit certain goods and services, but it's not permissible when you're looking for a fair specification to limit it in a way that is capricious or depends upon a characteristic that's not relevant. And for example, it's not relevant to look at different publics or what have you, or we say in this case, different media by which the advertising services could be deployed. And so therefore, if the advertising services in this case were deployed by way of insert, then that is sufficient to defend and maintain the whole of advertising services because the intended purpose is the same. And that's why it's right that there was no further limitation, because the proposed limitation is an artificial one. Well, I've rather raced through that, but that's all I need to say on the reply to
The cross appeal.
the cross appeal. I have nothing to further add to my part of the respondent's notice because that's the enhanced distinctiveness bit.
Yeah.
And I've said enough on that, and nothing really was raised that I need to add to. So that only leaves my learned junior, if you would indulge him. I've been told by him it won't take long.
Well, it's 4:20. I've got to think of the court staff. The transcriber's all right because we gave them a break. So it's really a question of how long do you think you'll be?
I would think somewhere around 10 minutes, my lords.
Well,
I know my learned friend also has a reply.
yeah, well, that sort of timing, then we will. I don't think it's indulging you. We'll hear you.
I'm grateful, my lords. I'll endeavour to be even faster than that, if I can. Use devices. So, my lords, if I may, the starting point, I think, is to take you to the judgment and to its paragraph 93, which, of course, you have in the core bundle, tab 11 and page 106. It begins at, because
Yeah.
this is the place where the judge sets out what the various services that the defendants had undertaken were. My learned friend, it wasn't part of his cross appeal, and my learned friend's confirmed today that the first of those categories, the advertising service that's set out in paragraph 93A, isn't the subject of any appeal. It's common ground that that was identical to part of the services which my client's marks were registered. But the services in issue were those in B and C, which are over at the top of page 107, and you've already had some reference to those, to the catalogue service and to the auction broadcast service. It is important in my submission to look reasonably closely at what those things were, because it's only in that light that my learned friend's submissions can probably be seen in the context of this dispute. So the catalogue service was a service which, I'm reading the words here, allows the auction houses to upload their auction catalogues and auction event details onto the defendant's website where they can be viewed by customers. And I understand that those were all precursors to those auctions actually being conducted, at least in part through the defendant service in part C, you see, which was the auction broadcast service, where the online platform for auction houses to broadcast their auction sales to customers and for customers to bid for lots for sale in those auctions was provided. I draw your attention to these because my overall submission, of course, will be that these are plainly retail services or plainly examples of the bringing together actions, bringing together services for which my client's marks were registered. With that one, I think the next point to look at is, again, the specifications of my client's marks. You've seen these already, so if I may very briefly just take you down to paragraph 96.
96.
96, so it's on page 107. It's a paraphrase of what you've already seen from the earlier paragraph of the judge's judgment, where he set these out in slightly more detail. But you see in 96A, which is the matter that's actually relevant for this part of the appeal, the element of the specification here of the Easylive stylized mark, which was in class 35 for bringing together. So it's the service was expressed in the specification to be the bringing together for the benefit of others of a variety of goods, enabling customers to conveniently view and purchase those goods. And I pause there because it's an important part of my learned friends submission that the submission developed into this, at least at the end, that by requiring customers to be enabled to purchase, that it required the provider of the services to engage in the contract for the sale of goods with those people. In my submission, that isn't the consequence of what that specification says. Plainly, in my submission, merely enabling customers to conveniently view or purchase the goods does not mean that one has to engage with them in a party-to-party sale of goods transaction. And one can think of a number of real-life scenarios that would illustrate that. My Lord Justice Arnold discussed with my learned friend the prospect of a supermarket having a browsing period before it formally opens for sale. But there's another example that the judge used in his judgment on the following page in 99, which is the core part of his finding on these services. And in the very last sentence of that paragraph 99, he records the submission of my learned leader, Mr. Edinburgh, who submitted that the average consumer of both types would regard what the defendants are doing as the provision of a marketplace, in essence a retail service. He goes on to say an online equivalent of the sort of service that a large department store or a markets often provide, whereby third-party concessions can operate on the service provider's premises. So it's central, in fact, to my learned friends submission that one would determine that a department store where different counters, different cash desks and an old-fashioned parlance within it were operated by independent businesses, the department store did not offer a bringing together service. It did not offer a retail service because it was not the entity actually engaging in the sale of goods transaction.
So John Lewis advertised Joe Malone
Yes.
perfume.
Yes, so there's a...
Or at least you can buy
Be
Joe
careful
Malone.
with John Lewis, but Selfridges would certainly be a good example.
Yes. I mean, yes, I'm not sure exactly how the business models would be. Well, I mean, that's a very good example. As a consumer going into John Lewis and going into Selfridges, it is completely opaque. I don't mean that in a critical sense, but you just simply don't know who your ultimate transaction is. But you go to those venues because you understand that they provide you a good bringing together service where you can choose goods and you are enabled to purchase them. Some will be the vendor. In other occasions, it's someone else who's the vendor. The earlier part of paragraph 99 is also important because this is where it really sets out the core of the judge's findings on this comparison of services. It may be fastest, my lords, if I just ask you to read from the 6th line that begins conveniently at the left-hand margin in my judgment and down to...
Which paragraph?
Paragraph 99, my lord. So it's in my submission, a plain finding that the judge made in that paragraph that did not think it mattered that the defendants did not curate goods to be included in the catalogue, nor that it is not the defendants who make the sale. And that was a finding in my submission plainly open to him, certainly not an error of principle to reach that conclusion. And it was on that basis that he held slightly earlier in the paragraph that the services that the defendants were offering fell within the specifications of the claimant's trademarks. I'm going to take 2 more points, my lords. First is just to touch on the specification of the Easylive word mark, which was the second of the marks that the judge had to deal with. He addresses that at paragraph 134 of the judgment. You've already been taken to this, but if I briefly may take you there again, it sets out the, again in paraphrase, sorry, it's page 114, my lords, sets out in paraphrase, paragraph 134, what that word mark was registered for. So class 35 retail services, I'm reading here from the end of the second line. Class 35 retail services, including online retailing and retailing through the medium of broadcasting, and then it was all for a wide range of goods. The point I take from that expression of the specification is that it's retail services including various things. So it isn't limited to those things. It is a specification that covers retail services of any nature. And so is even broader in my submission than the relevant specification of the stylized mark, which you've already seen. Again, my submission in respect of those is that the judge was perfectly entitled, and indeed correct, to conclude that the defendants' services all fell within retail services for the reasons the judge gave. Then I should also deal with the Practica-Bow case. It was the authority that my learned friend took you to, following questions from my Lord Justice Arnold.
Yes, I'd overlooked the fact that Mr. Akins had cited that in his skeleton.
My Lord Justice, I mean, it's referred to in both, of course, because we respond to it. I'd understood from my learned friend's skeleton argument this was really the principal basis on which this challenge to the judge's findings were made, almost that it's a finding of law that a retail service must include a party-to-party sale of goods transaction. But that's, in my submission, plainly not with what this case determined. One needs first, in my submission, to consider what the case was about. It wasn't about this issue at all. It was about a question of whether the activity that a retailer engages in was registrable as a service.
At all.
At all, yes. As opposed to, because the background to it is that simply selling goods is no different than using your trademark in respect of those goods. So someone like Samsung, for example, maybe they do have retail service provisions because they present a lot of their own goods in sole branded stores, but simply by selling their goods to the public, they don't offer retail services. That's what this case was about. One sees that, conveniently, if I could take you to the head note of it, so it's tab 7 of the first authorities bundle.
Bundle again?
Tab 7 of the first authorities
First,
bundle, page 127.
Yeah.
That's the first page of that tab. And then the head note at C to D, which just explains what the case was about. The applicant even further background, it was a reference from essentially the German courts after a failed application for a trademark at the German Patent and Trademark Office, a reference to the Court of Justice for a decision on whether someone could register retail trade in various types of goods as a service. And the final part of the first paragraph of the head note, just below D, deals with that point. Could it constitute a service in inverted commas? And if so, what the conditions were for registration of such a service as a trademark? One then sees how that was dealt with in that case, and the relevant paragraphs. First of all, my Lord Justice Arnold pointed out, in fact, it's recorded in paragraph 9 about the class headings in the Nice classification, class 35, which relates to a service.
Yeah, it's the explanatory note.
This is the point that my Lord made. Then there's a lot of background discussion, but the key passages in my submission begin on paragraph 34, my friend took you to. And this is the key paragraph that I understood he relied upon for the purposes of suggesting that retail trade needed to include a sales transaction. In my submission, that is not what the Court of Justice, even though this wasn't the point they were addressing, even in the paragraphs that my learned friend takes you to, that's not what they say. So the second sentence of 34 says the trade includes, and I pause on includes because it is an indication that this is not an exhaustive account of what retail trade in goods encompasses. Includes, in addition to the legal sales transaction, all activity carried out by the trader for the purposes of encouraging the conclusion of such a transaction. So even that sentence by itself, in my submission, undermines my learned friend's ground of appeal here, ground of his respondent's notice, I should say, because it indicates that retail trade is not limited to the sales transaction. It also covers all activity carried out by a trader for the purposes of encouraging the conclusion of a sale. And plainly, in my submission, that's what the defendants in this case do. The Court of Justice went on in that paragraph. The activity consists, inter alia, in selecting an assortment of goods offered for sale, in offering a variety of services aimed at inducing the consumer to conclude the above-mentioned transaction. So again, it doesn't require them to actually be the contracting party, but just as a service aimed at inducing the transaction. And it does say with the trader in question rather than with a competitor. But in my submission, that is simply that the normal aspect of any provision of services is to provide things for one trader rather than another. There are two further paragraphs, if I may just briefly take you to before I stop. And those are paragraph 44, because
Might be worth checking 39 on the way.
Oh.
Concept of services within inventory includes services provided in connection with retail trading goods.
Yes, my lord. Yes. So that was really the core of the conclusion that the Court of Justice dealt. The core of the conclusion it reached on the questions that it had been referred to deal with in that case, whether retail trade could be a service or not. So absolutely. For the purposes of this set of submissions from my learned friend, paragraph 44 is also relevant.
So you saw that.
No more restrictive.
No more restrictive than what we've seen in paragraph 34. So again, that was only exemplary. And then 49 is the final paragraph I draw your attention to, if I may, which is to say that, and again, I think this paragraph you've already seen, for the purposes of a registration of a trademark covering services in connection with the retail trade, it's not necessary to specify in detail the services. It is sufficient, it doesn't necessarily say it's necessary to do it in this way, but it's sufficient to use general wording, such as bringing together. And in my submission, both the bringing together specification of the stylized mark, plainly identical to the defendant's activity, the broader retail services, including various things of the word mark, also identical. And I will 41. I'm also reminded to take you to paragraph 41, which is on the previous page 134, which explains, in respect of some of the observations that the court had received, that the services eligible for protections, retail services, should be identified in a way which distinguishes them from services which, being closely connected with the sales of goods, could not give rise to a registration of a trademark. So this is again, it refers back to the point that the Court of Justice was in fact dealing with in that case, which was the distinction between someone really selling goods and someone seeking to register a trademark for a service in class 35. I should finally say, I think it was ultimately clear from the interactions between my learned friend and the court that the only challenge raised is to the judge's finding of identity in the services.
Well, he says that the but it's based on a misconstruction of the interpretation. So he says it has knock-on consequences in terms of similarity as well.
But if there is a challenge to highly similar in my submission, that's even worse for my learned friend. Plainly, the judge was able to reach that conclusion as an evaluation for the trial judge. So, apologies that my time estimate was about 50% of what it actually was. Those are my submissions.
Thank you very much. All right, well, we'll pause there.
Strictly speaking, Mr. Akins can reply on that last point.
I have no submissions to make in reply.
On any of it?
No, nothing in reply to the cross appeal or in reply to the.
Sorry for being so quick. I was great. So that concludes that appeal. We'll hear the linked appeal tomorrow. Makes me more confident that you can deal with the second appeal in the space of tomorrow. If you're as efficient as you have been today, which we would encourage, then that would be at least a potential possibility. All right, well, we'll come back at 10:30 tomorrow. 10:30.
Court, rise in favour.